one of the benefits of the common law is it combines stability with flexibility. Okay. Stability in the fact that since we have this legal concept called precedent, lawyers can look at prior cases, and if their case is fairly similar on the facts and the law and the issues involved, they can come to a pretty good prediction on what a judge is going to do. Not always, but usually. Okay. But the other great thing about the common law is it provides flexibility. When there is a new issue before a court that has never been decided before, for example, who gets possession of fertilized frozen egg embryos when a couple divorce? Believe me, the legislature never thought about making a law about that. And it actually happened. The case came up, a couple got divorced, and sure enough, they were fighting over the eggs. The husband wanted them destroyed. The woman wanted to keep them and fertilize herself later. There's no law that dealt with that. So the judges were free. The judge was free to say, hey, this is a new case. This is going to be decided under the common law. I can make whatever rule I want to. And that's exactly what he did. If you want to know what he did well, I don't want to get into that. But that's exactly what he did. So that shows you an example of the stability of the law and the flexibility because it allows new principles to be applied. Okay, now with comparison with the common law, we'll talk shortly about civil law. Okay, civil law is based upon a civil code. Most importantly, the code created by the Romans and later expanded by the great Napoleon Bonaparte. Okay, so civil law is based on old Roman law. And in a civil law jurisdiction, the idea of precedent and stare decisis does not even apply. In a civil law jurisdiction, judges are not free to make up their own laws. Well, you might ask, what do they do if it's a new case? Well, there's really nothing they can do. They have to wait for the legislature to deal with that. Okay, so in a civil law cases, all the law comes from the legislature. So in Louisiana, all the law comes from the states. The judges don't make up their own laws. Okay, so they look at the legislative code or the particular law that applies, and they're free to interpret it any way they want. Okay, the judge does not have to follow a decision of a higher court above him in Louisiana. He's free to wing it on his own. So if he thinks the judges above him are idiots and decided the case wrong, he's free to wing it and go his own way. Okay, you can see how this is a heck of a lot less predictable than the common law with our concept of stare decisis. So Louisiana is the only state. Like I said, Louisiana is a little different. God, I love them, but they got to do things their own way down the bayou. The next part of this lesson is going to be a little review of our system of government, and if you're just taking poli-sci or government or one of those classes, you might want to skip this part, but if you want to listen, that would be great too. Okay, so let's talk about the concept of what we call federalism. Okay, federalism is the concept of where we have two governments in America. Okay, we have the federal government back, those are the bozos back in Washington, D.C., and then we have the state government. Okay, those are the bozos up in Sacramento. Okay, and what creates the concept of federalism? Well, it's the United States Constitution. Okay, it establishes federalism and also what we call a tripartite system of government. Okay, tripartite meaning the executive, the legislative, and the judicial branch. Okay, states are set up the same way. Okay, they don't have to be. They're free to have their own constitutions, and every state has one. And as long as it doesn't contradict the federal constitution, they can set up their government in any way, as long as it's generally a democratic type of government. For example, Nebraska only has one branch of the state legislature, and in California we have two, which is, we have the Assembly and the Senate. Okay, state constitution is the legal foundation for their particular state. Okay, and then we have local governments as well. okay, and they're enabled by the state constitution, and they can pass laws too. They're generally called ordinances, and you know that's the way most states are set up. I'll generally be talking about how things are here in California. Okay, so federalism divides under the Constitution the lawmaking powers between the state and federal governments. Okay, now there are certain areas that the federal government has exclusive powers in. For example, bankruptcy law. Okay, there's no state bankruptcy law. Coining money, negotiating with foreign countries, and those are the exclusive powers of the federal government. Okay. And then there's certain areas where both the state and the federal government can enact laws in. I don't want to get into all the specifics of that, but the states are free pretty much to do anything they want unless the Constitution prohibits them from enacting laws in a certain area, or Congress has said you can't enact in those areas because we want to call what's called preemptive field. Okay, an example of preemption is like when we have we used to have a national speed limit at 55 miles an hour. Okay, God, that was sucked. Now Congress has decided that they want to allow states to have their own speed limits, and Montana they don't even have one. So I'm looking forward to Sunday going up there with a Maserati. Okay, so let's talk about the tripartite system. I always have trouble with that word. Okay, the legislative branch, as you know, passes laws. Okay, we call these laws generally statutes. Okay, the judicial branch, remember, because we're in the common law system, makes laws. Okay, in areas where the legislature has not made laws. They also interpret constitutions. For example, the Supreme Court gets to say what the Constitution means. The state government, the state Supreme Court here in California gets to say what the California Constitution means. Okay, so they interpret constitutions. They interpret statutes, okay, which are laws passed by the legislature, because this may shock you, but a lot of times when the legislature passes a law, even they don't know what it means, and then it's up to the courts to figure out exactly what it means and to apply it on a case-by-case basis, in particular controversies among litigants before the court. Okay, and we also have regulations, which are basically more refined laws. Okay, and they're passed by administrative agencies. We'll get into that later in the course. Okay, so their job is the court's job is to make laws, interpret them, and settle disputes between parties based upon the laws that were either created by the judges or passed by the legislature. And of course, the last branch is the executive. Okay, in California, the executive is Jerry Brown, and in the federal government, obviously that's the president, President Obama. Okay, and their job is to enforce the laws. Okay, so that's how the tripartite system of government works. The tripartite system was set up so that one branch could not get too much power. Okay, so that's what we call checks and balances. Okay, one of the major concerns of the people that wrote the Constitution, which were all men, unfortunately, was that one branch might be able to dominate the others if it got too much power, particularly the president. Okay, their big concern was the president would get too much power and he'd become a dictator. Okay, so that's why they spread out this this power among the three branches. Okay, so let's talk about some of the interplay between the three branches. Okay, now one important concept you have to understand is even though the judges can make common law, the legislature is free to change that law by passing a statute. Okay, so I gave you the example of the frozen embryo case. Okay, well, let's say the legislature didn't like the judge's decision and they decide that when a couple gets divorced, all frozen embryos should be destroyed. Okay, they could do that. On the other hand, they could pass a law that says the woman always gets custody. It'd be up to the legislature. But the point I'm trying to make is this, that the legislature is absolutely free to supersede or overrule the common law in most cases, unless they're trying to overrule a provision of the Constitution, which we'll get to in a minute. Okay, and also there are other examples, like, for example, the legislature can pass a law, the president can veto it, things like that. Okay, so those are examples of the interplay between the branches. Okay, the next thing that I want to talk about is the supremacy clause. Okay, the Constitution makes the Constitution the supreme law of the land, which means the Congress or any state legislature or even the Bakersfield City Council cannot make a law that conflicts with the Constitution. Okay, and you see this happening all the time in very hot button issues. For example, like Roe versus Wade. Okay, and a lot of the states in the South are right now trying to make more and more laws to restrict a woman's right to choose. Okay, I don't want to get into a big debate on abortion. I think there's good arguments on both sides, but the fact of the matter is these states keep trying to restrict women's options for abortion, and then it has to go to the Supreme Court or the federal courts, and they have to decide whether that particular law violates their prior precedent in Roe versus Wade and Casey versus Planned Parenthood and these other cases that the Supreme Court has decided. Okay, so the legislature cannot do an end run around the Constitution by passing a law. They have to stay within that construct, and if they don't, the Supreme Court or a federal court, or if it's a state constitution, they're free to the courts are free to strike down those laws if they feel they're in violation of the particular constitution at issue. Okay, and this brings us to the important concept of judicial review. Okay, judicial review was created in a case called Marbury versus Madison, the most famous case in American history. It was decided by John Marshall. And what Marshall said in that case is, I don't want to get into the facts of the case, they're really not important. But what Marshall did is he looked at the Constitution and he said, the Constitution, well, it's just a bunch of big laws. Okay, and laws are normally interpreted by judges. And so the Constitution is just one big law, and we're the biggest judges in the country. And so we get to say what the Constitution means. And so if we don't think a law, is congruent with the Constitution, we're free to strike it down. Okay. Interestingly enough, there's nothing in the Constitution itself that the Supreme Court gets to do this. Marshall just took it upon himself, and what a lot of people claim was a power grab on the part of the court, and decided, hey, we get the ultimate say on what the Constitution means. Okay, and there's interesting legal arguments as to whether Marshall or Marbury versus Madison was decided correctly or not. Be that as it may, it has been the law of the land for 200 years. It's the most important case in the history of the country, and it's unlikely that the legislature is going to come and try to challenge it now. Okay, so that's the concept of judicial review. Statutes can be reviewed by the courts to determine if they conflict with the Constitution, and if they do, they can be struck